Hi, everyone. Thanks for joining us for this LinkedIn Live conversation. We are David Tollen and Kathy O'Sullivan, colleagues at Tech Contracts Academy and Sycamore Legal, both of which David founded. Hi, David.
Hi, Kathy.
Today's topic, contracts about generative AI and issue spotter. Before we start, some quick housekeeping. We expect to go about 25 minutes, although we've been known to run over. While we're both attorneys, this conversation is for general educational purposes. It's not intended as legal advice or to create an attorney-client privilege, nor is it intended as attorney advertising. Regardless, know that legal situations differ and results depend on the unique law and facts that apply. At the end of the discussion, we'll share some resources you can use to keep learning. And please don't hesitate to offer comments and questions during the program in the comments section. We'll join you for a discussion on LinkedIn after the program. Finally, this conversation is being recorded and will be posted on LinkedIn. With that, let's dive in. Dave, can you help us start? What is generative AI?
Yeah, sure. So that's a fundamental question. It's not a wildly, tightly defined concept, but basically generative AI is artificial intelligence that creates unique new assets. So it truly looks like creativity. I'm sure a large part of our audience has used ChatGPT or one of its competitors. It really gives the appearance of the kind of creation that a human does, that a human brain does. It creates a new asset, text or audio or various different types of visuals are possible, can write software code. So that's generative AI. And the key to understanding it is that it is developed with machine learning. So it's developed with a system that it's not just programmed. And this is the key to machine learning. Most software does what you program it to do. Machine learning systems, particularly massive machine learning systems like much generative AI, is trained on huge amounts of data. And so its training is part of its programming. It's part of teaching it to do what it does. And the unique thing about it then is you've got to pour all this data into the system in order to get the AI to do what it's supposed to do. And that data usually comes from the vendor. There are some cases where the customer might be contributing data to the training of the AI, like if the customer is providing its own training data. And sometimes customer prompts, the customer's questions to the AI can go into the training data. So that's the sort of heart of generative AI, that it's got this machine learning component to it.
So what sorts of issues and contract terms should people be considering?
Yeah, so I'd put it this way. Yeah, go ahead.
I'm sorry, I misspoke. I'm realizing the central question for many people is, how are generative AI contracts different from either contracts about AI generally or about other contracts about information technology?
Yeah, so anytime we start a new contract about technology, we need to start with what in our firm we call the intake interview, where we figure out what the technology is supposed to do. And this is nothing unique to AI. You start out by figuring out what the technology is supposed to do. And artificial intelligence contracts don't necessarily take you in whole new weird directions when you do that. Generative AI, though, if you follow that process, you'll find some very different issues. There's some unique issues that arise out of generative AI because of that machine learning process that I mentioned. And by the way, the issues we're going to talk through, I've covered in a lot of detail in this issue spotter we posted online at techcontracts.com. And at the end, I'll give you a reference to that and a link to it. But there's really three sets of issues that arise as a result of the machine learning, as a result of the training that we get for generative AI. So first of all, so much data goes into these systems that no one can be sure what's in there. I mean, a system like ChatGPT is trained on most of the internet. So unlike with a lot of, software creation projects, with generative AI, the vendor doesn't know what went in there. Other systems, these art creation systems that you find online, like Night Cafe, they're trained on vast numbers of images scraped from the internet. So this creates an unusual set of issues that we'll talk about, which is that no one knows what went in. Second set of issues, generative AI and other forms of machine learning often keep learning as they're going. It's like normal software that's, as if you had a little programmer sitting next to you, and as you're using it, that person is reprogramming the software. That can happen with a lot of forms of machine learning. For instance, your prompts, the questions that you ask the generative AI system can turn into training data. And as I mentioned, sometimes the customer overtly, specifically, intentionally provides additional training data. So the system is changing, and the customer's inputs, the input data prompts, can play a role, and that creates a second set of issues. And then a third set of issues, thanks to all the uncertainty surrounding the data that went in, and thanks to the enormous complexity of the system itself, the enormous complexity of what the generative AI is going to do, no one knows what's going to come out. And there's the outputs the system produces can have unique problems like defamation, discrimination, racist content, intellectual property infringement, privacy issues. It has a greater potential for these sorts of problems in the outputs. And that creates a third set of issues. And again, this is not just generative AI. This is a set of machine learning issues, but we're particularly focused on generative AI.
So how do those three sets of issues impact contract terms in IT contracts?
Yeah. So again, we'll do a list of three. So there's a really specific set of three issues. So one is impact on trade secret protection. So the terms that you want around trade secrets, non-disclosure terms, et cetera, require some different thinking, some different maneuvering as a result of all this. Two is your liability related terms, warranties, indemnities, other liability terms related to the system's outputs. We're going to have some unusual issues there. And then third set of issues is about IP rights. It's who owns intellectual property rights in the data that goes in and the data that goes out. That's our three sets of terms that I think we have to consider kind of differently in generative AI deals.
That's great. So can we run through them one by one? Let's talk about the first one, trade secrets.
Okay. So trade secrets. So let's look at it initially and primarily from the customer's point of view. So this is where things can get a little weird, is for the customer's trade secret concerns. So what do you do about trade secrets in a contract? I mean, the primary vehicle you've got to protect, either party's trade secrets rights is non-disclosure terms. You've got terms that say that when, one party's sensitive information is in the other's hands, that other party won't misuse it, won't use it for anything but the relationship, etc. We got some weird twists and turns about that. So, any customer doing a deal, say, with an enterprise AI vendor, if for generative AI, is going to want those kinds of terms. It's going to want, if there's any trade secrets in its inputs into the AI and the data that it puts into the AI, it wants that protected. And then it may want trade secrets. It may want confidentiality protecting the outputs that the AI produces, which may be, central to its work. And it may, the outputs may include the trade secrets that went into the inputs. But we have some problems. So let's first of all talk about the inputs. So customer puts sensitive information into a prompt for the AI, ask the AI a question, and the question involves disclosing sensitive information. So that's fine, and it doesn't necessarily raise any unique issues in AI systems where that data is just being used to produce answers for the customer. But you you need to be aware if you're working on an AI system that takes your prompts and uses them to train itself for future customers. Both your prompts and any data you put in might be used for training for the AI, for ongoing training. And if so, you can't get the non-disclosure terms that you want. In fact, you're probably going to get from the vendor really an all caps disclaimer saying which there's no secrecy whatsoever to your prompts. They could be reused. And there's been already, there's been problems that have arisen with this, with systems like ChatGPT, of people putting in stuff that they shouldn't have put in. So you really need to be aware if data is that you're putting in, prompts, input data, whatever it might be, is used to train the system for the benefit of third parties. And if it's used to further train the system for your benefit as the customer, you just want to have terms that are clear about that. So we don't necessarily have weird issues surrounding trade secrets on the inputs, on the prompts, customer training data, et cetera. In those cases, like a lot of enterprise generative AI deals, where the data is just there to train the system for the benefit of that customer. But you gotta know if it's not. And if you're on the vendor side, if you're, taking your customers' prompts, consumer customers, corporate customers, whoever, and further training your system, you need all caps warnings about that. The vendor should be very clear that that's happening. So then the other side of the trade secret question is about outputs. So what trade secret rights could you have in output? So you're the customer of, say, a corporate enterprise AI type system, and it's producing stuff that you're going to use. You ask it to write software for you. You ask it to give you analyses of issues that arise in your company, and the data, that it's looking at may be confidential, and you want to protect what comes out. So normally what's your concern is it's that your vendor may have access, your tech vendor may have access to the outputs of its software. And so you want to make sure to control that. And that doesn't necessarily raise really unusual issues. And it should be possible for the vendor to accept normal sort of confidentiality terms about that. Vendors, though, you got to kind of watch out, and you should be doing this anytime you sign an NDA, which is you got to make sure that if you're agreeing that outputs are confidential, you haven't locked yourself down, tied yourself down to how you can use your own information. So your AI may be spitting out information it got from you, as well as information that's in the public domain, information scraped from the internet. It may not just be the sensitive stuff for the customer. And usually your NDA terms protect you from that. Usually NDA terms have a bunch of exceptions that say if the recipient got information that's already in the public domain or that it independently developed, that it's not subject to confidentiality. And that's all good. That should protect you. But if you're the provider and you're doing non-disclosure terms about outputs, make sure you do that. And then finally, another warning for the customer about the outputs. I mentioned at the beginning how we don't know the kind of thing that a generative AI solution is going to spit out. You don't know in advance whether a particular prompt, particular question to the AI is going to get you something that you care about keeping secret. It means you need to treat all of the outputs as confidential, at least initially. So this isn't contract terms. This is just your staff. If there's any chance they're going to get stuff you want to protect as trade secrets, they need to know to consider it confidential until someone has made an assessment. Do we care about the secrecy of this brand new information, brand new text, brand new software, whatever it is that has been created? And so it requires a level of procedure you may not have seen before. You got to take this, this software that's dumping information into your world and assume that the information is a trade secret until someone makes an assessment otherwise. And that adds a layer of hassle and procedure that's not normally there.
Those are really useful insights about NDAs and confidentiality. Let's move on to the second set of issues that you mentioned, which was, as I recall, warranties, indemnities, and other terms about liability. What's at stake there?
Okay, so here's another area where things get pretty weird with generative AI, because we have a couple sets of issues with the output. So Kathy, your question is about not the training data that goes in, but what is the generative AI going to spit out, and what are our liability issues? So normally you have at least potentially terms in your contract that has things like indemnities and warranties covering what the software does, saying things like, we're not, if we get sued for IP infringement as a result of the software's work, you're going to defend us. That's an IP indemnity, or warranting that the software won't infringe. Got some problems there. We've also got some problems about harm that the system could cause. So unlike with a lot of software, software's not going to make up defamatory content. Software, generally isn't going to spew racism, out of the blue. Software isn't going to do all kinds of, and software, hopefully isn't wildly inaccurate. We have low levels of accuracy from generative AI because of the unique flexibility that it has. And we have all of these risks, defamatory content. There's been lots of bizarre examples of AI making stuff up about someone, which could be tremendously damaging. So normally, what does the customer want? Customer wants to know that if its new software system is going to cause harm in one of these ways, that it'll have some liability, some responsibility for the vendor. So in a normal software deal, you'd have at least potentially things like warranties and indemnities about the system causing harm. This creates some unusual problems for the AI vendor, of course. From their point of view, with a system trained on a large chunk of the internet, they don't know precisely what went in. They don't know what's going to come out. They can't, these systems are so complex. Often the vendor itself doesn't really understand how the system is going to come up with its output. So long story short, for the vendor to say, we promise that we won't create something harmful, or we'll take on some liability if we create something harmful, is taking an enormous risk. And so I think if you've done any of these deals, you found the vendors don't want to do this. In fact, their inclination, and I think rightly so, is a broad disclaimer in all caps about the fact that the output could be anything, and both parties recognize that that it's unpredictable, and that it could include defamatory content, otherwise harmful content, erroneous content, that the customer should beware. Caveat emptor: the customer needs to verify. Any information, needs to review text before it goes out for harmful content, etc. So most, the vendors about these harm issues, is correct instinct is going to be to disclaim. It's a little problematic for the customers when you're just basically getting a, say, complete use at your own risk clause in the contract, especially in a, corporate deal, an enterprise deal. You're paying for this thing. Makes easier to swallow if you're just, clicking I accept to the terms of ChatGPT or something else that's free online. So from the customer point of view, what I'd say is, you may have to accept this. You can also, generally, if I'm on the customer side and I'm getting resistance to service level agreement terms or functionality terms, you want to push and explore and see what you can get. So it might be entirely possible for the vendor to make promises about how its technology itself will function, while disclaiming any promises about the output. So that's a line that the customer should consider drawing. Let's accept the disclaimer for liability about the outputs, but maybe there'll be, warranties of functionality and service level agreements about how the system is going to perform. You always want to push and test a vendor answer, there's nothing we can do. recognize in this case, that's the case with a lot of what's going on with the output. And then our second issue, I'm giving a long answer to this question, but the IP indemnity, the IP warranty that are typical in technology deals. Again, the vendor's got a real problem here. The output, yes, is very likely to include infringing material. There's a lot of open questions about machine learning training and whether that scraping of the internet for information to train is fair use under copyright law. But it's entirely possible that the AI produces an illustration or text that rings very similar to stuff that's out there. The vendor has another problem if it's going to make blanket promises about the outputs, which is the prompts, the inputs from the customer played a role in shaping the outputs. Once again, you're likely to see extremely limited IP indemnities and warranties from the vendor. The vendor, vendors, if you're smart, you're not offering any, you're disclaiming them. Again, if you're the customer, I say push and test. It's one thing to have the vendor disclaim any IP warranty or indemnity for outputs. That doesn't mean they can't separate outputs from their system and give you an indemnity that your use of their system isn't going to infringe, and make that indemnity or warranty specific to their software, so that you don't sort of open up this Pandora's box of other issues with the output. So I think that's the pushback from the customer side on very hard intellectual property issues. There's a lot to be figured out as time goes by with these types of AI, generative AI particularly.
Well, I'm sure we could talk for a much longer time about the liability issues coming out of generative AI, but
Yes.
let's switch to the third set of issues that you mentioned, which is also on a lot of people's minds. How does generative AI impact terms about ownership of AI?
Yeah, so normally, very simple, customer owns whatever it produces using the vendor's software, and the vendor's not going to interfere with that. We got some problems here too. So first of all, I want to make a note about this, which is the norm in a lot of contracts I see when we say, who's going to own an asset, like the customer wants to say, we own our data, is for the vendor to say, you own the data. And let's say the system, crunches the data and produces, derivative data, derived data. And you can say, you own that too, and we assign it to you. I think it's really a bad idea to assign an asset to somebody else when you don't know what's in the asset. And that's not just a generative AI issue. That's not just an AI issue. Why are you assigning? I mean, a lot of deals where we see an assignment of intellectual property, all that is really needed is for the vendor to not claim IP, is to say, we don't claim any rights to your data. The fact that you've given it to us doesn't give us, and we don't claim any exclusive rights to, what you've produced with it, but we're not assigning you anything. It's much safer to say, we're not making a claim on what you have, but we're not assigning anything. Keep that distinction in mind, because assigning can be risky. You can give up stuff that is yours. And that comes up in particular in generative AI outputs. So there might be an inclination to say that the vendor is going to assign all right, title, and interest into the output given to the customer. The vendor doesn't know what's in the output. Its own stuff could be in the output. Maybe the customer read part of the vendor's manual and put it into a prompt, and that comes back out in the output. Maybe the AI randomly comes across some of the vendor stuff online and puts it in, or maybe there's special training data from the vendor. In other words, a blanket assignment of ownership of the output to the customer is very risky for the vendor. Again, the vendor's better solution is to say, we're not making a claim on the output. You can do an assignment, but let me raise an issue why it's much more problematic than you might think. What's the vendor's role in creating this output? You got an AI system, the customer's going online, putting in the prompts, the output spits something out. The AI spits something out. If the vendor actually probably can't have any IP in that output. Why? The Copyright Office recently said an AI cannot produce a copyrightable work. There's similar law suggesting an AI cannot produce a patentable invention. Now, the line between human, if you're working with an AI and there's some human contribution and there's some AI contribution, it's not clear where the law is going to draw that line, and maybe there's something copyrightable or patentable there. But in our scenario where the customer is working on the vendor's AI and producing outputs, no vendor human was involved. And so there's actually nothing for the vendor to assign. Its role is purely AI, and AI does not, based on the laws we know it now, produce copyrightable or patentable subject matter. AI, by the way, could produce a trademark or a trade secret because those are not established through creation. It's through use, through protection, et cetera. So there isn't necessarily anything to worry about in terms of rights in outputs. I think if you're the customer, you do want to have terms that clearly say that the vendor is not putting any restrictions on your use of outputs. You can make any use you want of them. I don't know that you need a transfer of intellectual property. If you can get the vendor to make an assignment, great. But vendors, you should be careful about that. Then there's the issue. So that's ownership. The other thing you need to understand, and this is not specific to generative AI, but comes up here a lot, is it's not that meaningful to talk about ownership of data. And this applies to the input data, the training data, whatever it is. We get all this concern and angst over making sure we own our data. If you understand how intellectual property works, you can't really own data in any meaningful sense anyway. A lot of those clauses that say, customer owns the customer data, they don't mean very much. You're better focusing on control. You're better focusing on terms that says, list the things you don't want the other party to do with your data and make it a contract promise. Because even if you say you own it, your ownership might not restrict the other party from doing things like mining your data because of the weakness of IP. And by the way, I've explained this in many forums in more detail, and the issue spotter I'm going to give you at the end is one of them. So that's the issue with ownership of outputs. And let me just briefly address ownership and IP rights in the inputs and what the customer puts into a generative AI system. Again, it's going to want typical terms that says it owns all of those inputs. Again, I think from the vendor's point of view, you don't need to argue with that, but better to just not make a claim on ownership of the inputs, ownerships of the prompts. And again, I think your energy should be focused on control. Is the vendor going to make any additional use of the prompt? Is the prompt restricted to just asking this one question, or is the prompt on the other end of the spectrum used to train the AI? And you want to have very specific terms about that. So yes, you can say customer owns the whatever training data the customer provides in those systems where it does. You can say customer owns its prompts. Vendors, be really careful when you do that again, and make sure you say, except for anything that we previously had. It's like the exceptions to an NDA, except for anything we independently developed, previously had, could be found online, etc. But better to just say there's no transfer of ownership of the prompt to the vendor or of the training data. And then if you're really going to be making broad other use of the customer's prompts and training data, say for training the AI for purposes of other customers, all caps, just make sure that could not be clearer to the customer, particularly if you're dealing with consumers. But really, I think you want that kind of clarity in an enterprise deal also.
So shockingly, we've gone a little over.
It is shocking.
I know this was intended really as an issue spotter and to start the learning process. Where can our viewers go to learn more about this topic?
Yeah, so we have a lot of resources about this. So first and foremost is that issue spotter I mentioned. So this is a short issue spotter, this talk. I've put up a very long, detailed issue spotter for AI contracts generally. It's not specific to generative AI, but more of the issues relate to generative AI than anything else for obvious reasons. So it's called Artificial Intelligence Contracts and Issue Spotter. And it's at our website, techcontracts.com. And it's in 3 parts. It's broken into bullets. I like bullets for issue spotters. And we'll put up the link in the comments. And then next, we recently did an 1.25-hour webinar on this subject called AI Contracts Drafting and Negotiating. So that's past, but we are soon going to be doing we're about to be creating a library of recorded content where you can take our various trainings online, and that will be one of them. That will be one of the first released. So if you want to know about that when it's released, so that's a broader, more detailed version of this sort of talk. You can sign up to be notified at techcontracts.com. You can subscribe, or you can follow us here on LinkedIn. And then another thing we got coming is in November. November 16, we'll have a webinar specifically on not doing contracts about AI, but using AI to do contracts. And then finally, just to sort of plug for who we are and what we do, we also provide broad training on drafting and negotiating technology contracts, which particularly lately always includes artificial intelligence contracts. So we have webinars listed at techcontracts.com. We have a series of master classes, 8-hour classes broken into 4 that teach you all the key terms in technology contracts. And we have a new series is going to start on November 7, and then another one, a new series on September 7 and run for 4 weeks. And then a second one on November 7. So you take that virtually and do 2 hours. And then, as I said, we will have that library of video courses. So to be informed about any of that, follow us here on LinkedIn or subscribe. So just, finally to close, Kathy, if I could just keep in mind, artificial intelligence, it's software. What you know about doing software contracts is not somehow invalidated. It just means, as with any new software, you got to absorb how it works, what it does, and figure out what twists and turns there are. With generative AI, there's an unusual number of twists and turns, and I hope I've given you a roadmap to figuring them out. And thank you for joining us, and thank you, Kathy.
Thank you. It's been great.
Bye.
Bye.